On 27 December 2022, the Commission sent you a request for submission of the 5-year declaration of assets and personal interests. On 3 January of this year, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire, and you did so on the 4th of July of last year. The Commission sent you 2 rounds of questions on 27 January and on 9 February 2023, respectively. You were asked a total number of 21 questions, including 63 subparts, and 34 of the questions included a request for further documentation. According to Article 3, Paragraph 4 of the Evaluation Rules of the Commission, a candidate may not provide information, documents or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless the candidate provides sufficient justification for not providing the information as requested. Members of the Commission will now start with asking you questions. Vitaly Miron will start with asking questions. We will try to keep our questions short and to the point, and we ask that your answers be short and to the point as well. Vitaly, you have the floor.
Madam Chiriac, I would also like to greet you and welcome you. According to a pre-established algorithm, I will now ask you a number of questions regarding certain matters that we'd like to know more about. I would like to say that you're already familiar with these subjects because we already addressed them in our previous communication, the communication between the Commission and the candidate. So I will jump straight into the topic. So you founded Nuferi Pelag, a limited liability company, on the 23rd of July 2020. And this company provides leisure and recreational activities in the district of Kalarash. This company leased 8 land plots from your son, who is the current owner of the leased land plots. The ownership rights over these land plots were transferred to your son as a donation from your husband, who, in his turn, inherited the land plots from his father. So they were not inherited. It was actually donated, not inherited. Apologies for this mistake. So he's not. Well, that was not an inheritance. That was a donation. Thank you. I looked into the excerpt and I apologize for this mistake. So the main attraction of this company, according to the public information, including social media platforms, are the water lilies grown in the drainage channel that is nearby the land plots. It's on the same drainage channel that your company organizes some boat tours. And just to make it simple and to make it comfortable, because it's sad, it's like a drainage channel for irrigation purposes, so we will just call it a channel to make it more convenient and consistent to use. According to the e-cadastre database, that particular drainage channel that your company is using for private activities is not part of the lands that are leased to the aforementioned limited liability company. What is more, this drainage channel is located on a non-registered plot, which means it's public property, and the Commission asks you to provide confirmation documents of ownership or the right to use the drainage channel where your company carries out those activities. And in the first round of questions and answers, you specified that lake, which is rather an irrigation channel, was not registered according to all the requirements of the law, that the process has been protracted by the father-in-law, then by the husband, got stuck in all the paperwork that had to be carried out and worked with, and thus the lake, so to speak, continues to appear as farmland in the document and is included in the lease agreement with the son. Next, continuing the quoting you, in time, I will try to give it a legal status, but as far as I know, this is a very expensive process, and even I didn't have enough time and patience to deal with it. You also attached a copy of a decision of the Council of Tozara Commune number 0406 from the 22nd of April 2003. And this authority gave your father-in-law the right to use that water body for irrigation purposes. In your answers provided to the Commission, you stated that the tunnel was on the land plots number, well, for purposes to protect personal data, I will not say what the cadastral number is, but they end in 001, 002. So you perhaps know what that is. And Nufer-Pelac has the right, the rights of ownership and use for the land that it is leasing. And you also stated that there were some issues with the cadastral registration of the land, which was imprecise. And in that regard, you've also annexed a letter from the mayor's office, which confirmed that the e-cadastre data was imprecise without, though, specifying what exactly that imprecision was about. On the 13th of February 2023, the Commission sent an inquiry to the Tozara Commune Mayor's Office, and in the answer provided on the 21st of February 2023, the Mayor's Office confirmed that the limitations of the plots were not accurate. However, when asked whether the channel is located within the 001 and 002 plots, the answer was that the irrigation channel is located on a part of the private plots with the aforementioned cadastral numbers 002 and 001. Now, to address this issue, I'd like to ask you a number of questions. Please confirm that in the second round, question 3b, you stated that the lake, whether irrigation channel is located on land plots numbers 002 and 001, not beyond them, and that Nufer-Pelac LLC has been renting it, and therefore you have the rights of ownership and use. I feel like smiling, because if you were there, I mean, it speaks for itself. If you were there to see it with your own eyes, you can see that the lake is on that indicated land plot, not on public property. And to provide more context, well, it might have been my mistake. There are certain matters that I left to my husband to deal with because they did not belong to me. I had nothing to do with those land plots. They were donated by his parents, and then further on, the land plots were donated onto the son. And the problem is that when the land was distributed, you can see the delimitations now, even to this day, when this delimitation was carried out. And the lake, we call it a lake. I mean, I think it sounds prettier, lake, because it doesn't sound nice to grow water lilies in an irrigation channel. So that's why we went for the word lake. However, you need to know that it's quite stilted there, and the water is not quite good quality, good, so to speak. So there's the channel that is like the way that I just indicated, and there's another bit of it going this other way. So there's a little bit of a border. So there was an enlargement that my husband did, and that is a delimitation performed by Călăraș Mayor's Office. And to the right, there's also a piece of land that belongs to the Călăraș LPA. So without a cadastral engineer from Tozara Township, well, nothing was performed, nothing was done without having that other person on board. Way back in time now, according to my husband and my father-in-law, who has passed away, but they were told back then, this is your property. From here and from till there, that's your property, my husband, that is. And then my property was delimited again. So if we look at the e-cadastre data, that is completely different than the actual delimitation of ground, of land plots on the ground there. So, because if we were to follow what the e-cadastre says, it means that the land of my parents-in-law would be beyond the railway, but it's not like that, in fact. So, Madam Chiriac, we will look into that further. I would like to tell you that you should rest reassured, because the irrigation channel was expanded into the land that belongs now to my son, Chiriac Constantin. It was expanded into that direction. I just would like to mention this. You've also grown up in the countryside. If you take 1 centimeter away from a neighbor or from Tuzara mayor's office, where I registered the agreement on leasing that land, I was not objected. I was not told anything was wrong. I mean, I'm just renting it. Everybody told me it was fine. I've been going there for 20 years. I've been going there. Nobody, not once, nobody said a word as to the fact that we would have taken something that wasn't ours. And I took the lease agreement with the Tuzara LPA and I registered it there. And nobody told me that I took away something that wasn't mine, that I'm using, so even 1 centimeter that is not mine. And in this particular case, when I heard for the first time that in the e-cadastro database there's something else, I only found out when I filed my application to the commission. And thank you for that, because after that, I wrote to the mayor's office in Tuzara, to the district architect, and they confirmed that Tuzara mayor's office doesn't have a cadastral layout for the entire township of theirs. They do not have it in place because they do not have the funds. There are no funds to carry out all those measurements for all the land plots, because in fact they are located in a different way. I mean, that parcel, that plot that you see to the left, I mean, it's delimited. There's another irrigation tunnel where the water would drain into from that land plots. Well, I will have to interrupt you. We will look into that. We will look into these matters that you've just mentioned, that you just raised, and we have a couple of questions to raise yet. So I would like you to answer the question that is asked so as to streamline this exchange. So tell me, please, in the second round, you mentioned that this lake is on the land that was rented from your son, is it correct? And a couple of seconds or minutes ago, you mentioned that in fact this irrigation tunnel was expanded into this land that belongs to your son. Now, for more clarity at this stage, could you be more precise? Was it expanded, enlarged into 002 and 001 land plots that belong to your son and that are being rented by you? So, is it only a part on that line, or in full is it there? I have personally not seen what it was like initially. I can't confirm that. But when I looked at the perpendicular channel, that's 50 centimeters where the water was flowing. So I imagine it was the same situation. But I can't confirm because I didn't see it. I did not see it. I did not go there. I did not see what was there initially to start with. When I got married to my husband, everything was already in place. So what can I tell you now? Everything that I know is that the channel is on our land, and the opposite part, there is a plot that is very narrow and that belongs to Tuzara mayor's office, to the Tuzara LPA. And my son suggested we could rent a bit of that because it's a very little piece of land that belongs to another owner. So there's a very narrow plot, and Tuzara LPA said that we can rent that little narrow piece of land only after they will have measured all the land plots. But that is something very expensive to do, and they said then we will be able to go back to this question. But it is true that indeed the left side of it does not belong to us, it's not ours, and we do not use it. It's only that part that there was an enlargement into and towards the railway. If you had a look at the map, I think you understand what I'm saying, what I'm talking about. And therefore, that iron wagon that is there, that container is there, not on public property. Well, you said that you didn't know what the situation was there on the ground before you rented and started to use this irrigation tunnel. So I would like to ask you, so in the second round, question 3, I will quote you that although it was not, although we did not finish registering the ownership rights, and although the right on the use of waters was not registered for the aforementioned reasons, the land belonged, the land under it belonged to us. What do you mean when you said, when you mentioned right to use. I think you misunderstood me. The water doesn't belong to us. The water belongs to the government. But the bottom of the lake belongs to us, and therefore the plants and the roots in the land, in the soil, it's ours, our flowers, our land, our grounds. Now, about the irrigation channel, who did it belong to? The irrigation channel is on the land that belongs to my son. But I have to be honest that after all of these hardships now that I'm going through, all I can do is to terminate the lease agreement, and this will put an end to everything and let my men deal with it further. Well, that is not the purpose of the Commission. That is not the topic of this discussion. And now, Madam Chiriac. I was never fond of land, so that like karma, that I must have loved the land, and then I would have had this issue. I should have loved the land that I carry out my activity on. According to your answer number 19, provided on the 10th of February 2023, you presented to the Commission. So LPA Tuzara claims that the real estate located in the contour 2544, where there are hundreds of properties, where your land, or the land that we're talking about, is also found, that does not correspond to the existing situation on the ground, because the geodetic measurements were carried out without connection to the National Geodetic Network. You communicated to the Commission that after the errors made under the Pământ program will have been corrected, the subject regarding the use of the lake would be exhausted. In this context, please explain what are the legal and factual grounds that give you this assurance that after the new measurements are carried out, this problem regarding the use of this irrigation channel will go away. And if I may ask you to clarify, I mean, Tuzara LPA, Tuzara Mayor's Office said that for the reasons stated above, there could be certain inconsistencies in terms of the borders. So the question rather is, what makes you feel that this problem will go away once the errors are corrected, the errors that were allegedly committed are corrected? As long as measurements are carried out, I know they will go back to what initially was in place, because people there, they are growing agricultural produce for more than 20 years since that land was appropriated to them. I feel certain that everything is, in fact, the way it is now there on the ground. We're not going beyond the railways. We're not encroaching upon the territory of anyone there to the left or to the right. So having the legal basis for the land, we will register also the irrigation channel. There's not a problem with that. What I only found out last night is that for such an irrigation channel, because I've already got in touch with all the cadastral specialists, I don't think they slept well this period of time. Only 50 meters you could only have 50 meters of irrigation channel without a layout approved. It's not a lake, it's an irrigation channel, and back in that time, that was perfectly legal. So that's why that did not appear in the decisions of the mayor's office, because according to the law from back in 1996-97, that was absolutely legal to have to build an irrigation channel, but not wider than 50 meters. And our lake is 30. The width of our lake, of that irrigation channel of ours, is 30 meters, 30. So of course, if all the parcels, if the lot plots are delimited properly, then we can do all that we have to legalize the ownership over the land under the irrigation channel and the irrigation channel itself. Now that I see that this issue is out, I've also talked to the district-level architect, Madam Tatiana Chiriac. I asked her what we can do about it to make things official, to make it legal, because we were thinking about doing something even more intricate than that there in that space, but because we don't have a cadastral layout for the township, all the measurements contain errors, and I was recommended by her not to do anything now. So although I was thinking about having a book cafe there, I was also thinking of it to be like a mobile construction that I could move around any time that I felt like it. And because I can't be given a construction permit on that land that is farmland, first of all, but also because even if we wanted to change the destination of the land, we can't do it, because on the ground it's one thing, e-cadastre has a completely different thing. Now, just to clarify, I mean, This is the matter that we're trying to understand. It's reflected in the question that I asked. The mayor's office says that that in that delimitation, in that outline, there are inconsistencies with regards to the borders of the land plots, which means, well, in the Q&A rounds, you stated that the irrigation channel is a component part of the agricultural land that you are renting. So I would like to repeat that's the question. Now, starting off from the position of the mayor's office, that there's an issue with the entire outline. What makes you feel like once the errors are corrected, this issue will go away? I would like to repeat that without the cadastral engineer from the mayor's office, nothing was distributed. I mean, it wasn't possible to distribute anything or illegally. Nobody did any illegal movement without, so to speak, the knowledge of the engineer at the mayor's office. So it was all done with knowledge of the engineer. You can come to see for yourselves that you can see the delimitation posts are still there, reflecting the delimitation back in the time. Even as a judge, there were a lot of litigations that I was aware of, particularly regarding the delimitation of land plots. And you said that there was an orchard, but this only means that the data in the e-cadastre is not updated. There is no orchard whatsoever there. The information there is not up to date, so we have neighbors. I mean, you can't just encroach upon the land plot of somebody else. So our irrigation channel couldn't have gone into the railway if there weren't there was some construction. I mean, if there wasn't some land that was already measured and delimited, then I would maybe I would have had doubts about it. But I know that there is no way for us to make a step away from the limitation that is already there, not to the left nor to the right. I mean, when the proper measurements are done, they will reflect the situation that is actually there on the ground. So that's why the mayor's office, my husband, and the district architect tell me to stay reassured about this matter. So all I'm saying is conveying what I was told by the specialist. And it's also from my experience for years. We did not move at all. I mean, we did not encroach upon or twist past beyond the delimitation that we had. There's a channel, there's a railway, we couldn't have done it. And on the right-hand side, there's the railway. And according to the law, it has more than 50. There's this land plot that is adjacent to that is supposed to be 50 meters. So I understand this, but let me ask you in a different way. According to the information from the real estate registry cadastre, the lands with cadastral numbers, as we said, 001 and 002, were assigned to your father-in-law in the year 2000, and they were assigned cadastral numbers, and they had a surface area established and their destination and location in 2001 as a result of an application submitted by your father-in-law to the LPA in Tuzara. The Council of Tuzara decided to allow the applicant to rebuild the irrigation channel, the water drainage channel that borders the plots of land that were mentioned, that were distributed as equivalent shares back in the day. According to the plan, to the layout that is annexed to that decision and that is component part of the aforementioned decision, there is a clear demarcation between the land plots with cadastral numbers 001 or 02 leased by Nufir Pelak Limited Liability Company and this irrigation channel. So how can you explain this? How do you explain this? I think only my father-in-law could have provided an explanation. Apologies, but what else can I tell you? I know that it doesn't border their land. I know that it is part of the land. It's not bordering it, so they're right next to one another. I mean, it can't be any other way. As far as I was told, and as far as I know, this irrigation channel was enlarged into their land shares. Otherwise, they wouldn't have been allowed to do it. Because my father-in-law was not someone to try to use just to his own advantage public property. According to the decision that I refer to, in stricto sensu, in the narrow sense, if you look at that decision, then it allows to rebuild. It was just to rebuild an already existing asset. And further on, and we will address this matter too, it was then transferred into use for irrigation purposes. So initially, Tuzara LPA allowed your father-in-law to rebuild an already existing tunnel that, according to the annex, which is component part of the decision of LPA Tuzara, is a distinct asset in relation to the land. So, are you challenging the existence of this decision or the information that I'm now sharing with you, or is it you're challenging the information that you yourself submitted to the Commission? I would like to reiterate, what does rebuild or reconstruct mean? Did it build it up, build it down? What does it mean? It was enlarged. It was enlarged into the land that already belonged to. So that's how I understood the decision, and that's my understanding of it. And the current mayor, Madam Burghera, she used to be the secretary of the mayor's office, and she has a very good memory of these details. And I just conveyed to you what she told me. I personally did not participate in any affair whatsoever in this regard, so I can't confirm or refute this information, but I know for certain that the irrigation channel, there was a permission to enlarge, to rebuild, to enlarge this irrigation channel into the land that belonged already to the owner of the time, and that were distributed to the owners at the border of a very small irrigation channel that is now there in a perpendicular the current channel that water was just draining into. And by enlarging this channel into the land that belonged already to the owner, that made the swamp go away. So I would like to read again the first point of that decision to make sure that we are on the same page. So according to the decision number from 2011 on the reconstruction of this water drainage channel, item 1 allows citizen Chiriac to use his own resources to deepen and expand the channel because of the silting up and flooding of the adjacent land plot that belongs to Chiriac, to the citizen. So you're saying that the LPA allowed for the expansion to be into the privately owned land. What do you mean? I mean, the decision doesn't contain this wording. That is the problem of the LPA, but I would like to tell you that it was not only the land of my father-in-law, the land belonging to my mother-in-law was also there adjacent. And indeed, by expanding it I'm not sure which one was the first and which was the second, but I know for certain there were 2 land plots. Now I know it by heart myself, something that I didn't want to know in the past. So by enlarging into the land of one of them has saved the other land plots because there was a swamp there and one couldn't grow anything there and was not next to it, but into that land. So if that is necessary, I'll let the mayor's office provide more details. I can't tell you any more than that. I know that it was a bit more than 1 hectare long, and my mother-in-law had a bit more than 1 hectare, and now it's like 0.4, 0.48 or something like that. I'm not certain. Please believe me, I never looked into the very details of it as regards sizes and cadastral numbers. That is not my cup of tea. I don't know. I never really thought about it. But whatever was received back then, it's not like that. More than half of that land is under the lake.
Please, I apologize for my insistence, but I've got this question. On one hand, you say you don't know, you are not aware. At the same time, you state that the mayoralty allowed the expansion of this object on the account of farming land plots. And I read an abstract from the decision. I am sorry, I don't understand what is in that. It is allowed, based on his own resources, to deepen and expand the existing channel because of silting up and flooding of adjacent land plot belonging to him. But expanding based on what? Based on what land plot? Expanding it where? What is not clear there? I'm sorry. Based on what or towards? Does it say to expand it into public land? Ms. Chiriac, we are here to clarify this. I want to, but probably I'm not speaking Romanian. How can you expand it? On the account of what land? The land plot on the right or on the left side? There are several options. I mean, Does my statement make sense? I don't know. Logic is a very broad science. I am telling you that it was enlarged to the right on the account of land plots that belong to them. Otherwise, the mayoralty wouldn't have allowed them in any way to expand it into public land. Why would they have done? I mean, does it say anywhere that it was expanded onto public land? In the context, when they afforded the reconstruction of an asset that the mayoralty has the right to dispose of. As long as it doesn't say that it is expanded onto public land, this is how the mayor assured me. She used to be the secretary of the mayoralty at that time, and she remembers this very well. She informed me, because I was done with clarifying it with my husband. I just made sure that it was on the account of land plots that belong to Chiriac Mikhail. Otherwise, there is no other land plot to expand into. That is everything I can declare here. And I have nothing else to add. I told you it was done on the account of their land plots. This is what the mayor told me, confirmed to me, because I've been there repeatedly, so that they would show me what is not going well there. Because we have never had any issue with any neighbor. We didn't have any issues with the mayoralty. Ms. Chiriac, we're not talking about issues. Please let me finish. There are local councillors who are quite cautious. I assure you that no even 1 centimeter of land that doesn't belong to you, you will not able to hold. This is not the time when everyone did what they wanted. No. I was there on site like 3 times with the cadastral engineer. I asked him, like, show me please, I wanted to know, even though it's not any of my interests. And he explained this was on the account of the land plots of your father-in-law. Your answer is accepted. Can we move on to the next question? Thank you. In 2003, as a result of a request submitted by your father-in-law to local public authority of Tuzara, the Tuzara Commune Council adopted a decision by means of which it assigned the channel with an area of 0.6 hectares for irrigation purposes. The basis for that decision was Article 24-26 of the Water Code, Law number 1523 of 1993, which essentially state that only the water bodies that belong to the local public authority can be assigned for separate use. So which means that the right for separate use for irrigation purposes of the drainage channel will transfer to your father-in-law, which means that at that time the local authority qualified this water body as public property. How do you comment on that? I mean, there are 2 decisions of the right to dispose of a certain object. I would like the mayor to come here in front, instead of me, and all councillors who adopted such decisions. I know, and that what I've known is that we didn't harm anyone's interest, especially public interest, but why were such decisions adopted? I don't know, and why after so many years, because I was not part of that. I did not know about that. I saw them only now that they exist, and what can I say? I mean, if the mayoralty wants, I return this channel together with the flowers. I'd rather give up on it than fight. And this is about me, this is my nature. So if the measurements are done, and if it is proven that this is not done on the account of land plots that don't belong to us legally, not me personally, but the ones who inherited, I will be the first one to return these land plots with the channel, with the flowers, and with everything. Do you admit such a hypothetical scenario? No, I do not admit it, because I am sure everything is legal. This is just a misunderstanding. It is just an unclarity. But if we are given that the land plot that we have, like 2 or 3 hectares, whatever we have, if they give it to us onto the railway territory, I will take a part of the railway and it will be a better investment. I am sorry for my insistence, but we need to clarify, to shed light on this, so I am sorry. I apologized to you before I came here. Thank you. Madam Chiriac, do you doubt that local public authority in 2003 transferred to your father-in-law a channel with a territory of 0.6 hectares? What do you mean, do I doubt it? How can I doubt that? How can I doubt a document that was not challenged by anyone? So you don't doubt that? I believe that everything was legal. After the measurements, there will be more clarity. Don't try to catch me on statements, because this statement doesn't mean anything. We are lawyers here. I cannot tell you that I doubt it or I don't doubt it. What I certainly do not doubt is the fact that I did not harm anyone's interests, especially public interests. And that is something that I do not doubt, because once more, there is a cadastral engineer who even now confirmed everything that was done in the past and how it was distributed in reality. You don't know what neighbors we have there. If we took an extra centimeter, well, we'd rather give them more out of our land. Ms. Chiriac, I'd like to explain also that the purpose of the commission and of a member asking questions is not to catch a candidate, it's just to ask questions about certain issues that were identified and receive appropriate answers. That is the context. Then why do you ask me, do I state that or not? I can state that there are lilies. It's beautiful out there, and that's all. Ms. Candidate, I'm not asking about the beauty of that place. That is what matters for me. I am asking you precisely if you accept, or do you have any doubts the existence of a decision, or do you have any counter-argument? Because in the written communication with the Commission, you insist that the entire existing channel that Non-judicial LLC benefits from is located on farmland that are being leased. At the same time, in the description part and the context of the question, it is clear that this irrigation channel, by the right of disposition of a local authority, was transferred to your father-in-law, at least part of it, 0.6 hectares. In this context, do you agree with this information? Do you not agree with it? I know that the 0.6 hectares belonged to him as property. What was given for him to use is the water, but the land under the water belonged to him. And I think I explained it enough already based on what I know. Those 0.6 hectares belonged to Chiriac Mikhail. But this statement contradicts the decision. Another reason to have a transfer the possession to him does not exist. I mean, why would they transfer it to him and not to someone else? I would like to mention that by the decision of Tuzara Local Authority 2003, they transferred into use for irrigation purposes, not for, it was not transferred as ownership. So it was the water that was transferred, not the land under it. So according to the mentioned decision, it was transferred for irrigation purposes, certainly to your father-in-law, 0.6 hectares. Can you explain what's the legal reason based on which Non-judicial Limited Liability Company uses these 0.6 hectares currently? I think I have explained everything earlier, because the land was donated to the husband donated to the son. I leased it from my son, including these 0.6 hectares. Non-judicial LLC leased these 0.6 hectares of land plot that are now under the water of the irrigation channel. To conclude another question, I mentioned two decisions of Tuzara Local Authority regarding the management and the right to dispose of this water body, irrigation channel, which passed the legality control exercised by the State Chancellery. These decisions say that this channel is public property, and this is the reason why local public authority of Tuzara exercised its right to dispose of it. How do you comment this? I will not comment anymore. I just have not seen such information, and I don't know what to comment. I have not seen it in front of my eyes. What I have seen is what I told you. The donation agreements, I did not check with the state chancellery and elsewhere. I just worked closely with Tuzara mayoralty, because that's where I registered the authority, or the activity, sorry, of the company. That's where I registered the commercial, air quote, commercial activity. It's not a big economic. So as a lessor of the land plots and as a founder and manager of Nufer Pelak in 2020 was assured that I was assured that all my activity on those land plots is legal, because there was no argument. No one told me that something was wrong there. Not even to mention that the mayoralty, the mayor of Tuzara, even the cadastral engineer, they were there repeatedly, they saw how everything is located, and I have never had any objection. So I could not doubt that I could not have any doubts that I would be using something illegally or something does not belong to my son from whom I was leasing the land. So this is everything I can tell you. Of course, after the hearing and actually talk about everything is a financial issue, because all land plots need to be measured again, even though I know that it will be as it is, but within e-cadastre, as in hundreds, thousands of cases that were measured by means of permanent land programs, a lot of land plots are not reflected in the system as they are in reality. Many land plots are overlapping, and currently there are lots of cases in court for this reason. I know that you know this better than me, because if you talk to employees from Cadastre, I was told that there are hundreds, thousands of such cases, and indeed Tuzara mayoralty asked for correction of the situation in this land plot, but it does not have the needed financial resources currently, because it is extremely expensive to do that. Because after I saw that there are these issues, I saw that maybe we could pay, even though we're not that rich to afford that, but to pay and to delineate at least what are our land plots, and we were land plots, and we were told that that is not possible. It is possible only if you take the entire contour, so only with the support of a mayoralty and of a new project that I don't remember the name of, because you know, I don't have a sincere connection with the land. I hope I will not get into it soon. Then and only then we will be able to get clarity, and I think that all questions will disappear then. I have nothing else to add. Madam Chiriac, I would like to finish the questions about this topic, but for clarity, you mentioned that you cannot comment these decisions because you did not see. This is what draws our attention. Because in the last question that I asked about the legality, or legality control performed by the State Chancellery about these two, what I wanted to say, I know how the State Chancellery used to check the decision. Allow me to continue my question, please. You mentioned that you can't comment because you did not see this decision. And this is my dissonance, because it was you who provided them to the Commission, or did I misunderstand this? What exactly did you not see, and what exactly can't you comment? You said that they were checked by the State Chancellery. I presumed that there is such a decision, that the State Chancellery deems them legal. That's what I meant. I did not see such a decision of a State Chancellery saying that such decisions are wrong or correct. Moreover, you added that according to the decision of a state chancellery, these land plots would be public. No. I saw the decisions of the mayoralty. There was a misunderstanding. I cannot deny, because it does not represent me. I saw the decisions. I submitted them, but the fact that they were checked as required by the state chancellery, I really have doubts about that. Because I know during those years and generally, if the state chancellery is not told by someone like to look closer, if the state chancellery is not told to be more cautious, all decisions of local public authorities passed by all local councillors, especially the ones passed unanimously with no objections, they were accepted as they are. I am convinced that you capacity, you know that decisions of local public authorities have to undergo a mandatory control. It's not just only upon notification, but they undergo a mandatory control within the state chancellery, and if there is a problem, then they notify. Actually, you answered with certainty about this one, but given the complexity of this topic, would you like anything else to this? Or all comments were made and the position is clear? I am a person that fulfills her dreams, always. This was a dream that was unachievable for me, to grow water lilies. But, there's good and there's evil. The good or the bad thing. The good thing is that I managed, I brought some wonderful, amazing things in those areas. Because there is everything in Chisinau, but in Kalarash, not a lot of things exist. So I received a lot of positive reviews, because maybe I was, as we say, drunk on cold water. Like I was too early thinking. I did not examine too thoroughly on what is happening, because no one told me. I did everything honestly, out of all my heart. But, well, I did it, but I can also give up on it as soon as I see that something is wrong. I can step back. But anyway, this will not help now with the location of land plots. Of course, we will do everything possible not to have any shadow, any taint of unclarity or doubt on the name of the company that we started. Everyone can tell you that they get receipts for what they pay, and this is out in a field, and I know you people from Moldova, you understand what that means. I could just make a place and have people come there. No. I did everything legal. I registered a shop that actually does not exist. We don't have such resources. But in order to have a cash register, and that souvenir or a book like the Lotus story would be sold, and a receipt would be given in order not to have any shadow of doubt cast on me personally, I did everything that I could personally, of course, with the support of my family members. But what resulted, well, we will correct it. I want to sleep. I do sleep well. I did not harm anyone's interest. In the countryside, people know how to protect and delineate their property. Everything is the way it was distributed by the cadastral engineer back then, and the current cadastral engineer, he confirmed that in nature they allocated correctly, but there is a big mistake in the e-cadastre. If we move land plots, as it shows in the we will move into a property of a person on the left side, which is growing produce there for 20 years. He has nothing to give us, and we cannot aspire towards someone else's property. But if you go on site, you look at this channel and this channel, they delineate strictly our land plots. But, as I said, well, I look inside. I hated that place because it was taking time of my husband, his salary from our family, and this is the payout for that. Thank you. Chairperson, actually, I completed the question for the first issue, or first part of issue 1. If there are no other questions, I can move to the second part of issue 1. Would you please use microphones? I don't know if you're speaking.
So,
the first issue consists of two parts. If there are no other questions about these matters, I'm ready to go on. Madam Chiriac, another perspective on the situation. According to the lease contract of 7th of August 2020, provided to the Commission on 30th of January 2023, Nufer-Pelac LLC leased several agricultural land plots with a total area of around 1.7 hectares from the Sun, with the mentioned purpose used as farming land, including that was mentioned in the contract that was provided. According to Article 36 of the Land Code, enforced at that time, farming land, regardless of form of ownership, are used for carrying out activity for purpose of obtaining agricultural products and for the location of agricultural infrastructure objects and tourist reception structures in the category of guest houses or agrotourism, including with what was mentioned for paragraph 2, letter C. And given that these lands have a special purpose of farming lands, they can be used according to this purpose, or for this purpose only, sorry. And they can be used, namely, in order to obtain agricultural products, to obtain energy products in conditions stipulated by Land Code. They can be used for location of, to locate agricultural infrastructure objects, and also to locate tourist reception structures in the category of agrotourism structures. In view of the above, please mention what kind of activities Nufer-Pelac LLC performing on those leased lands that have a farming purpose, out of the ones that were mentioned. Grows grass. That's all. Because in the types of activity of Nufer-Pelac LLC includes providing camping services. And the people who would like, they can bring their own tent, because we have like lawn, well-cared grass, and the trees that were planted back by my in-laws. There is another land plot, and but I can tell because I did not lease the entire land plot. There is a part of it where my husband plants some melons and cucumbers. I mean, from what I know, there are almost 4 hectares altogether. What I leased as a Nufer-Pelac LLC is grass. And if I'm not mistaken, a couple of rows of vineyard that were planted, I don't know when, also planted on our land. Going back to the question, we focus specifically on the activity of Nufer-Pelac LLC, not on your husband's work. So you leasing this land plots. Yes, there is just wild grass. We are cutting, we take care of it. So, okay, you mentioned that growing grass. I would like to finish my idea. If a person comes and wants to camp on our territory, they can pick a place and put the tent where they want, on the grass. Your answer is accepted, but I would like to elaborate on this question in order to understand what do you mean precisely. And I mentioned the provisions of Article 36 of the Land Code, which provide for the ways that farming land can be used. To reiterate, they can be used in order to obtain farming produce. That's the first option. To obtain energy products in line with the Land Code. They can be used to locate agriculture objects and to locate agrotourism guest houses that are part of tourist objects. You mentioned that Nufer-Pelac LLC uses these lands to grow grass. So please, try to fit this activity in one of the options listed at Article 36 of the Land Code. As you saw, there are some agricultural structures set for agriculture. That's that big container as a shop. cradle, a swing, that people can, it's part of the activity, and people can make photos there. And I think that agricultural work do not prohibit you leaving it to have grass on it. The land plots are cared for, but no one obliges me, according to the land code, to plant there something specifically. It neither obliges me nor prohibits me to do. I decided that I wanted it to be green. I wanted grass on that land. That's all. We don't have a possibility, I and my family, they don't have a possibility to get entirely involved there in order to make sure that we grow something and harvest. This is another area that I haven't gotten into yet, but I can assure you that these land plots are well cared of, grass is growing there, and some infrastructure objects that are related to the activity of the company. Nuperpelak, that's the swing. What else? We have a Chinese-style bench where people can sit and also make photos. And that's it. I mean, we don't have agricultural produce. Sometimes we plant like some sunflowers, but it's for beauty purposes. Maybe I can say that that is agricultural produce. But to my shame, I didn't harvest it. Ms. Chiriac, well, maybe I don't understand the question. Ms. Chiriac, I will try to reiterate. Maybe we don't grow any agricultural produce on that land plots, those land plots. I did not ask you that. Nuferpelac LLC leases farming land plots. According to the land code, such land plots can be used in line with Article 36. Please tell me, what do I violate? That will make more clarity for me. I cannot tell you that you violate. I just want to shed light on the situation. I don't understand the core of the question. I don't make any statements that you violated something. I reiterate, Nuferpelac LLC leases some farming land plots. These land plots, given their special purpose, can be used only in line with the provisions of the land code. Article 36 lists clearly what are the options of using such land plots that have agricultural purpose. First of all, to obtain agricultural produce, or to obtain energy products, or to locate the agricultural infrastructure object, or agrotouristic guest houses. Well, leisure and recreation area, does that mean that tourists are coming? Is that a question to me? No, I think I understood what you mean. I think it seemed to. I hope you understood. And then the answer is what? That the land plots, these land plots, of course, are used to receive tourists. Because recreational leisure area means receiving tourists. And we also, of course, we don't have a guest house yet, but for the future, that's what I was been thinking, that we will transform it into an agro-tourism guest house, only when we have the capacity to build it. And on those land plots, we want to grow fruit, vegetables, everything natural, in order to be in line with the status of an agritourism guest house. But the leisure space and provision of camping services, touring services, of course, we are using these lands. This is where we walk, this is where we sit down. Ms. Chiriac, I will have a last attempt to clarify this issue. You are talking about future and outlooks, but I'm asking you right now, out of the options provided for in Article 36 of the Land Code, there are 4 options based on the purpose or destination of such land plots, based on the purpose of your lease contract between Nuferpelac and your son, which prove that these land plots can be used for farming purposes. Please identify right now. Nuferpelac LLC uses these land plots compared to the provisions of Article 36. In what category do you include your type of activity?
Agro, guest house, and tourism. Thank you very much for this answer. Now, if we take that as a further starting point, one can deduce that in the government, according to Government Decision 643 of May 2003 regarding the approval of the methodological norms and criteria for the classification of tourist reception structures with accommodation and catering functions, well, that decision expressly defines the types of tourist reception structures or bodies. So a tourist guest house is a tourist reception structure located in the urban or rural area intended for the tourist accommodation with a capacity between 3 and 20 rooms operating in private homes or independent buildings, which ensures both preparation and serving of meals. And an agro-tourism guest house is a tourist reception body located in a rural locality or on agricultural land without changing the destination of the respective land, intended for tourist accommodation with a capacity between 3 and 20 rooms operating in private homes or in independent buildings which provide part of the tourist's food with products from their own household. So please specify in which of the above categories would the activity that Serenofit Belak is carrying out at this moment, what category would it fall? And does it meet the criteria of the government decision? When I registered it with the state registration temper, and when I mentioned the recreational space that I had in mind, they said that certainly in our certification, in our register, that according to our certificate, we meet what is meant by rural tourism. As for the agro-tourism guest house, this might be the case in the future. We don't have the rooms yet, so at that time, though, however, I was not aware of this when I was registering the company. When I registered the company, I was thinking that everything was absolutely fine with the land. That's what I thought. And the first thing I did, I talked to the district architect to obtain a permit and a construction authorization. And I was told that the cadastral layout of Tuzara has not been finished off, and right now you can't build anything whatsoever because all of these years I was applying for, I am sure that otherwise over these years I would have applied to different projects and I would have built the guest house. However, I didn't know that e-cadastre has a totally different information in it. I was just told that the cadastral layout of Tuzara does not exist, and in that instance, we are not able to give you a construction permit for anything at all. We can't do that, I was told. So that's why what we did was very minimal, modest, and we would only limited ourselves to tourist reception in a rural setting. So rural tourism is what we focused on. Yes, I was thinking about a guest house when I registered the limited liability company, and we would have built something. It's not that hard to build a building with 3 rooms, but I didn't have the possibility to, because year over year, just to provide some details, our work is seasonal. We just work up for a few months in summer only. So at the very outset even, I wanted something that would be an annual activity all year round, because even now people are calling me saying that they would like to come over to see the water lilies, and I was thinking, okay, in summer we're going to have water lilies, and in the winter we'll do something else, because that's a very picturesque and beautiful place with beautiful landscapes. But I did not purposefully violate anything, and the guest house would have otherwise been built at this moment in time. So that's what I told the person in charge of registering the business. I said, look, I want to have a recreational and leisure space. We're going to grow water lilies there. And I was recommended the activities that were listed in the registration certificate. I hid nothing. I did nothing that, in my opinion, would have been a violation of the law. But year over year, I would be told, wait for another while. We've applied for the project. We'll do the measurements, I was being told, because everything depends on those measurements. The village of Tuzara doesn't have a cadastral layout. People can't build houses in the village. And we are out there in the fields away from the village. So imagine. And I also noticed that people liked it. All the obstacles I was up against were making me think to shut it down completely. I mean, in 3 years, you need to have shown people something if they show interest in their turn. And for the reason that we were not able to build anything, and because we had, even with this modular container, we've had issues with that. I mean, we have what we have, but people won't come every year to just see the same thing. Yes, the water lilies themselves are charming, and people understand that, but we never had any issues and doubts around it because, as I said, the people who visited us, they received these receipts on what they were provided. And I'm mostly engaged into volunteering. I talk to children, to adults. We talk about water lilies and all sort of handicraft. And I would like to assure you that there will be a guest house one day. But once we sort things out with the land, that is the key issue, the land and the legal status. Madam Chiriac, thank you. This was everything from me regarding this matter, regarding this issue. However, I will also ask you now if there's anything you'd like to add, considering the complexity of this issue. Well, I would like to say that if it wasn't for this issue, I wouldn't have grown water lilies, because if I say that, the water lilies will get mad at me, and that'll be worse. So we will do our best to get things right, to sort things out. I did not encroach upon the interests of anybody, and I'm actually happy that I applied with the Commission, and now I know what is up with our land in there.
For follow-up questions, Victoria, go ahead.
Good morning. And I have some questions that have to do with failure to submit asset declarations and declarations of personal interest when you were appointed to and when you left the service of the Kalarash Court. So briefly, I'll read you a factual background, and then we'll get to some questions. You were employed as the head of evidence and procedural documentation section within the Kalarash Court on June 5, 2013. According to Article 8 of Law 1264/2002, concerning the declaration and control of incomes and assets of state dignitaries, judges, prosecutors, and civil servants, Paragraph 1 establishes that the declaration shall be submitted within 20 days of the appointment or election to office. According to the National Integrity Authority, there is no record of a declaration submitted when you were appointed. The same situation exists with respect to your release from office in 2016. You left your position as then the head of the Secretariat at the Kalarash Court on May 10, 2016. According again to Article 8 of Law 1264/2002, Paragraph 3 establishes that at the end of the mandate or the termination of the activity, persons who are required to file declarations are obliged to submit a new declaration regarding income and property that they own at the time. According to NIA, again, there is no record of a declaration being submitted when you resigned. In both cases, you were asked to explain whether you had submitted the declarations, and if you had submitted them, to provide a confirmatory document. You did not provide any confirmatory documents. You explained that you remember that you submitted your declaration when you assumed office to the head of the court secretariat, who would then send them on as appropriate. The former head of secretariat is now in Canada. With respect to the declaration when you left office, you state that you also submitted that declaration because you always tried to comply with the law and not to have weaknesses that could be used later. But due to your, and I quote, previous employment litigation with the former president of the court, she possibly did everything in her powers for your declaration not to be filed in line with the legal procedure. There are annual NIA declarations on file for you for 2013, 2014, and 2015. Please confirm that you were employed as head of evidence and procedural documentation section at the Kalarash Court from 2013 to 2014, and that you were employed at the court for that from 2013 to 2016, and you were required to file annual declarations of income and property.
I confirm that I worked there and I was under the obligation to file those declarations.
Okay. Between October 1st, 2014 and May 5, 2016, you served as Chief of Secretariat of the Kalarash Court, and that was the position you resigned from in 2016. And NIA does not have a record of declarations filed by you when you assumed your position with the court and when you left your position.
I don't know if I need to, perhaps I need to expand a little bit the context. There are certain sensitive matters that I wanted to leave behind. I worked in Kalarash as judge. When I returned because the president of the court asked me to give them a hand in that section for procedural documentation. There was a lot of work to be done. There was an older lady working there, and she had to leave, to retire. So I accepted. Now, to go back to the declaration, I am sure that I filed it, but I was going back to a collective of people that I worked with before, and some of the workers used to be subordinates to me, my subordinates. So there were certain things that happened, some of them that I found out only now. So my mistake is that I did file the declaration. I remember that very well. I was issued a confirmation of the fact that I submitted it. My mistake is that I'm not a career person. I'm not the kind of person to keep everything. I made the big mistake in my life to think that everybody thinks like myself. I did not keep all these documents confirming the submission of declarations. So perhaps I put them somewhere away. Well, usually what I don't need, I burn. I don't even throw away. I either burn or destroy them. So I did not find anything. So honestly speaking, I'm not very fond of the memories of back then, so I wouldn't want to go into those memories of that time. It is not possible for me not to have filed the declaration, especially when I left. I did submit the declaration. I remember submitting it the next year with the Strasheny court because the courts were merged. In 2014, I remember for certain that the head of the Secretariat would collect from everyone the declarations, mine included, upon appointment into office. And I was confirmed. She told me she sent it because at the time they would send them through the post office. It was not by uploading it on the website, as far as I can remember, but maybe I might be mistaken. Now, another thing is that it's a mistake, considering I've always learned to live with dignity and openly. I didn't think it was something that important to keep all the pieces of evidence that I filed something, that I would ever need to prove anything to anyone. I never thought I would need it. I am as honest as I can be now. When I left in 2016 from the court, I thought I would never go back. I would never go back to where it would never return to the system.
And just to make sure I understand, when you filed your initial declaration, assuming office, you submitted that to, is it correct, then the then head of the Secretariat of the court?
Шефу.
Okay.
Да.
Yes.
Sign anything when you submitted the declaration?
We would sign the declaration, and he, the head of the Secretariat, would sign that they received it and would give us a confirmation of the fact. I even remember it, I can picture it in my mind. It says, I confirm that I received from you the declaration of assets on one assuming position, but I can't remember where I put it. I don't have it to give it to you.
Okay, and so...
And it's that, we would do that every year for a number of years, for as long as I worked there. That's how we would do it. We would submit them, and we would be given this confirmation from him. And maybe it's there with the court now, but I didn't try to go there and to inquire into it. And he would also keep some records in the register, perhaps. I can't tell. I don't know. For certain, I did not see it, but I know that he was taking some notes on his own, but he left. If he were somewhere nearby, then maybe I could have asked him, but I'm not sure whether he could have confirmed or otherwise anything, if he remembered. I know for certain that I submitted it, but to now look for these little notes, I don't know. Didn't even have the time to be honest. But most likely I threw those notes away, that I destroyed them.
Okay, so you did receive a confirmation when you filed the assuming office declaration, and you don't have a copy of the confirmation, and you also didn't keep a copy of the declaration itself, is that correct?
You know, I looked into my computer as well. I thought it could have been there in digital form, and I mean, I should have kept it in Word. I remember I introduced everything I had and worked on my computer at work, and then I put it all on a USB flash, and I can't find it now. I did not copy that information into my computer at home, because all these declarations I would fill in at work. When I left, I took all that information, I put it on a USB stick, and I can't find it now. I don't know what happened to what I did with it. Once I left from that position, I went through quite difficult times, and in fact, just this really sort of, I skipped my attention completely. And maybe in that period, maybe because we didn't particularly sell, didn't particularly buy anything back in the day, we didn't acquire new property, so I felt very comfortable with it. I mean, the same garage, the same apartment, and just these land plots that have made my life dark. And nothing else, and perhaps that is the reason why I didn't pay that much attention. And, well, the salary can be checked anytime. All income can be checked anytime through the tax inspectorate. So that's why I did not pay due attention. Now I understand that I made a mistake, but when I left too, I am sure I submitted a declaration. But, well, those who live in Moldova know that we had huge issues. I had huge issues with the president of the court, and she had no interest in me leaving my position in honesty, with everything in the right place. So I don't know what to tell you, only that I know for certain that I submitted the declaration. When I left, I submitted the declaration too.
And with respect to when you actually left office, do you remember when in time you submitted it? How long after you actually left the court?
I think no more than 2-3 weeks will have passed, not more than that, because I know I was thinking about it. I will submit the declaration, and I will leave, and I will completely forget everything that has happened to me in this recent past. For a long time after, when I left in the beginning of 2017, I know that a civil servant must submit still in the next year a declaration. I know that for certain, because I went to the Strashen court, and there already the Kalarash court and Strashen court were merged, and there I submitted a declaration on assets too, and I am sure about it. I'm certain about it. There was even a stamp on it, because I was not working there anymore, and I went to this records unit well, there's a unit on records, on documentation of the population, but I could maybe look into that. But the memories that I have of the time were so ugly that I prefer to just erase it. But I am certain that in 2016, when I left, in 2017, I've also, in the first months of the year, submitted the declarations.
Okay, and you had been the head of the secretariat for the Kalarash court, and by the time you left, it had merged with the Strashen court, correct? No. Okay. So if you had left, who did you submit your leaving office declaration to in 2016 when you left?
In 2016, I submitted it with a Kalarash court. I mean, the law had been passed, but as far as I can remember, it hadn't been enforced yet at the time. So when I left, I think I left in the first half of the year in May, I think, and then until next year in January, February, when I filed the declaration, at the time already there was only one president of the court, as in by the time the courts were already merged. Kalarash and Strashen courts were already merged at that time. But when I left, I filed my declaration with the Kalarash court, and I know that for certain because the president was Madam Valentina Krychkova. In Strashen, there was a different president of the court already, and I remember that I filed one. I submitted one with the Kalarash court when I left, and another one, the other one, with Strashen court. I can remember that very well, very clearly, because these are two different towns, and the presidents of the courts were different, so I know that very well.
So if I understand correctly, it's your contention that you also filed an annual declaration for 2016. Okay. Now, did you receive confirmation for either or both of the declaration filed in 2016 when you left office and for the declaration filed for the annual declaration for 2016 that you filed the following year? Did you also get confirmation for those filings?
When I left from Kalarash, when I resigned from Kalarash court, there was no other head of secretariat and not even the head of the unit for the evidence and procedural documentation unit. I mean, there was no one to replace me, to take my place. So I submitted it to the unit of evidence and procedural documentation for the reason that to have a proof of the fact that I submitted it, because the relationship between myself and the administration were extraordinarily hostile, and I know for certain because I wanted just to be sure that there is this stamp, a stamp confirming submission. So all correspondence of myself with the president, it would all go through that unit on evidence and procedural documentation. We would all go through that unit because that was the only way for me to prove what I was doing and that I submitted and to confirm all my actions. The same happened in Strashen. I remember for certain that a stamp confirming submission was there on the declaration of assets.
Okay. But did you receive confirmation when you filed the declaration, when you left office, did you receive confirmation that the declaration had been filed, as you did with the one when you assumed office?
No, I did not receive it because there was no one to receive that confirmation from. There was no one to give me that confirmation. So I left the declaration. I was certain that I submitted it, and there was no one to ask the confirmation from. And it was my understanding back then of the situation that I thought I would never, ever need those confirmations again, that I would never be a civil servant again. But I did not pick up any confirmation whatsoever. For me, it was enough that there was a stamp on the declaration confirming receipt at Kalarash court and then at Strashen court. So it was only the stamp, the seal.
You filed the declaration the following year. That was filed with the court secretariat, correct?
When I went there, the head of the secretariat was not at the court. But for me to travel there, to commute, I mean, I went there and I thought it was enough to file it with that head of evidence and documentation. I mean, that unit where all the documentation goes to when it comes to the court. So I had that stamp confirming submission. I thought that was proof for me. I had the proof of having filed it. So I did not ask for anything else in addition to that, because after a while, I have had serious health issues and I left the country.
Okay, and you did not keep copies of any of the declarations that you filed? Okay.
You know, I don't want to promise. I can make another attempt to look for them, but people who know me know that I like perfection and for things to be orderly, so I clean things away. I don't keep old things. I'm not sure I kept it, but I will try to do my best. If I have time, I'll try to look somewhere for it, but I don't feel sure that I kept it. I don't want to promise and then not live up to this promise.
The Commission, in response to questions, that because of your previous employment litigation with the former president of the court, she possibly did everything in her powers for your declaration not to be filed in line with the legal procedure. Is that correct?
Yes, I confirm that.
And the she you were referring to was the president of the court, correct? Okay.
Yes.
When you say that she possibly did everything in her powers for your declaration not to be filed, do you have any specific information about actions taken to prevent your declarations from being filed?
No, that was rather like a general remark. I knew she hated me a lot, and I had that suspicion, but I cannot provide any piece of evidence whatsoever. But out of the discussions with the staff that was still working at the court, because I've had some good relations established as well with people working there, I knew she was very angry at me because I spoke out about certain things happening inside the court, and particularly acts of corruption that she was involved in, and I had the suspicion that she could do this because when I was hired there to work, I was told that the court didn't need so much fairness. Madam Chiriac, this hearing will be aired online, will be available online. So I just want telling you this so that you know if you want to certainly make these statements, knowing that it's going to be online, because it doesn't have to do specifically with this particular case. So I just wanted to remind you that this is not an in-camera hearing. I know, but this is something that everybody is aware of, and I have nothing to hide. I just had this suspicion. I might be wrong indeed, but knowing how much I've heard and how many things have happened behind my back, I wouldn't be surprised if this was the case. What I wanted to say is that although I was trying to do things right with honesty all the time, I was always trying to be open. They would always try to tell me that nobody needs this and that things are different, in fact. And thus, it is very hard for me to say that it's one thing or the other, but I went through that, and when there was articles in the media, there was a meeting of the Superior Council of Magistracy, and all the decisions were public, and whoever wants to look more into where it would have, I think, the possibility to, because I think there are some public materials as well. So I am not saying anything that is in any way a secret.
Okay, so your litigation with the court began in March of 2016, is that correct?
Perhaps. Now when I look back, it's hard for me to tell exactly what happened, where it's hard for me to figure that out now.
And so but that litigation had not occurred when you started with the court in 2013, correct?
Well, let's say that they didn't like me from the very beginning. She didn't like my going back to work there. A while ago, she came to replace me in my position of judge. And for some reason, people think that I should have had some resentments about it, that I should resent her. I thought that maybe she didn't know who I was and what kind of a person I was, because I feel I have accountability for all my decisions. But from the very first days, I was told that I was not welcome there. And obviously, what followed was...
Your dispute and your litigation with the court came after 2013. So that was the reason why your 2013 declaration wasn't on file, correct?
The head of the Secretariat had also once been my subordinate. Well, ultimately, I do not want to start being suspicious about people. I know I submitted it, and I didn't have a litigation with a court, a litigation with a person, and that person was further in charge of the court, like managing the court, but I didn't have a problem or a litigation with a court, just to make sure that.
There are declarations on file for 2013, 2014, and 2015, so nobody interfered with the filing of those.
Well, perhaps I can't remember now, but you know, when you would file them all, because we would all file them at the end of the year, I mean, there is no way for mine to have disappeared. It would have been too obvious. Why would only my declaration disappear upon appointment and upon when I left? Why didn't one of those that we were all filing at the end of the year go missing? It would have been too obvious, too visible for only one declaration to be lost, right? Because there are also lawyers working there, and they work within the framework of the law, so to speak, in quotation marks. Why are only the one's declaration upon my assuming of office and upon my termination when I left? Why did only those declarations disappear and not those within the years that I worked there? All the staff would file the declarations all at once, and all the declarations would be filed at once and put together and then taken, all of them, and taken to the agency. So I only found out that they were missing now because of this evaluation. I felt certain in my heart that I had filed them, and I was absolutely did not have any worry about it. I have no other explanation.
And in 2016, however, when you left, if you believed the court president was doing everything in her power to cause trouble for you, and you were trying to avoid weaknesses that could be used later, why didn't you get a receipt or ask for a copy of your declaration?
I said that, and I would repeat, I never thought I would be back in the public service of any kind. I was so confident that these systems are mutilating people, the judicial system, the public service altogether, so that I was strongly believing that I'd never be back. And the fact that I knew that I filed it, that I did not gather any other property, I did not hide anything, I did not do anything deliberately bad, that made me to be less cautious. But I'd like to say it again, that in half a year, I think, I don't remember, it's hard to remember those years, but for like half a year I had to suffer some tough things. But I wasn't in the country, I left everything, because that's what meant taking a step back for me.
And I think you mentioned earlier that you might have been able to check the court to see what was registered or potentially for records. Could you tell us what efforts you made when the commission asked you questions about the missing declarations, what efforts you made to see if you could locate them or locate some record of them being filed?
I made the only effort to recall, to remember. I checked back home in the documents that I still have. I could make an attempt through the documents that I have in a box somewhere, stored in the garage somewhere. I will try to go through this as well.
And is there anything you would like to add or clarify with respect to this issue?
Probably just the only thing that I did not do anything deliberately, and I believe that I obeyed all legal provisions at that time. And I am glad that even now, when I filed all declarations of wealth and assets, you probably did not see big differences between what I had and what I have now. As I said, I did not gather anything new, I did not hide anything, I did not dispose of these receipts deliberately. Honestly, Well, I don't want to repeat things. I just did not think that this is so important because I did not think I'd be ever running for a public position in this country. I was thinking that I would only develop personally, spiritually, a business that I did in a very good way. But I just did not think I'd ever be back in the public service or in the judiciary particularly.
I have no further questions.
Sorry, then back to the last round of questions. Vitali, you have the floor again. Yeah.
Madam Chiriac, I would like us to try to approach an issue about some cars that you own and owned. In 2015, your family became the owner of a car model Honda CR-V, make year 2011. In your 2015 declaration of income and property submitted to NIA, you declared that the purchase price was 100,000 lei for the car. You sold this car 2 years later, in 2017, for the declared price of 100,000 lei, which is reflected in your 5-year declaration you submitted to the Commission. Subsequently, the Commission received the sale agreement of 14th of September 2017, which shows a sale price of 50,000 lei. The Commission found out that this Honda CR-V car was imported in Moldova in late 2014. The official price reported by the Customs Service for that specific car was 180,000 lei plus paid duties for another 31,000 lei, which amounts to a total of 211,000 lei, which was significantly lower than the price of the car stated. You stated that according to the husband's, what husband tell you, this car was bought from a person who imported it from Sweden, and that car had erosion of the whole car body. So please confirm that in 2015 you purchased a Honda CR-V car. Probably yes. I told you it's difficult to me to clarify all the years, but we had such a car. I don't know exactly the model, but yes, we had it, we used it. This car was manufactured in 2011, which means it was 4 years old at the time. Yes. Please confirm that in your 2015 year declaration, you declared that it was sold for 100,000 lei. Well, if it's in the declaration, that's it. That's what I mentioned. How can I deny if that's what's said in the declaration? From what I know, our colleagues, before the hearing, provided you a set of documents. Okay, let's say it is like that, probably. I do not contest, I do not doubt. If you don't contest, it's okay. If you do disagree, you can look at the documents and revise the information. Please confirm that when the purchase agreement for this car was requested, 2015, that was in the first round of questions, you answered, and we quote, the agreement was not kept, and the Public Services Agency subdivision in Călăraș disposed of a copy, and therefore you were not able to provide a copy of the agreement. I said, that is based on what my husband told me. Well, is the quote correct? Read it once more, please. I'll repeat it. Please confirm that when the agreement on the sale of the car, purchase, when we purchased it, okay, because they're all sale purchase agreements, I was just wanted to make sure. So we're talking about the purchase. I was not at it. So we quote that the agreement was not kept, and the Public Services Agency subdivision in Călăraș destroyed their copy, and therefore you are not able to provide a copy of the agreement. Yes. To explain a little, I think it's not a secret for the Commission, because we have a media here. My husband worked for many years head of record keeping and transport record keeping and registration in Kalarash district. And of course, everything that I wrote there, I consulted his opinion on that, because honestly, as a lawyer, personally, I did not interest. I asked him, do we have this contract? He said, I did not keep it, because I asked everyone to help me to collect all the documents, and I was told that we did not keep that one, because according to their internal rules, after 6 years, all these contracts are burned. Well, that's what he told me, and that's what I'm telling you. We accept your answer. As mentioned, you were given a number of documents, including documents from the Customs Service regarding the evaluation of this car. Do you agree, or do you confirm, or do you disagree that according to the information provided to you, and you can take a look at it, this car was imported in 2014 with a customs value of 211,000 lei. I can neither confirm or deny that. If that's it, that's it. I don't know if you have any other questions. Maybe I'll answer later on. If you need to consult this information, that is even to... I prefer to believe in legal documents, even if it damages me. So, if you say that the customs assessed it like that, that's what I understood. True. Yes. It means that that's what was. How can I say something else? Answer accepted. How do you explain that you declared this car being sold for 100,000 while the declared import value was 211,000? Here I'd like to go into some more details. You realize that having a husband working for so many years in this specific field, registration, evaluation, exams and so on for transportation, I did not handle this aspect at all. And now, when I saw it, I was told that the price of the car is this one. The husband told me. I checked. Yes, it was new, but it was like corroded all over. We never had a lot of money to afford buying new cars. But every time, my husband would buy a car that looked nice, so that I'd like it, so the woman would like it, you know, but it had lots and lots of deficiencies that subsequently my husband was handling, because that was his work. He knew all professionals that could take all this corrosion. He could assess if someone who would assess if the car had any accidents. So it wouldn't work with him to try to mislead him. Look at it, it's shining, it's good. He knew that shining was only for me. From a technical point of view, it was his car. So we purchased it at the declared price. This is the price that my husband told me. Thank you that the land plots and the cars were on the part of my husband, and you are a man, and you know how much you like it when your woman mixes up with your car. That's why I prefer to believe him, because I knew that in our family we don't have big amounts of money to buy a new car, so that I would see the receipt, which I always like to see the receipt with the amount, everything. Moreover, you know, working in this field, he knew a lot of people who were bringing cars from abroad. And he asked, please bring us a car that would fit the money that I have available. Probably that's how it happened, from what I remember. Again, it looked so nice, it even seemed new, but you know very well that abroad they use them much as possible, and then it gets heat or some corrosion, and then they come and sell them here. That's what I can say. Microphone, please, because I can't hear Vitalia. I will repeat the question. Based on what you declared a couple of seconds ago, you did declare that this car was imported for you specifically. I just want to understand exactly what you meant, because that's what you said. Well, I have a suspicion now, probably, but I cannot affirm that statement. I did not handle it. They brought it, they showed it to me. Do you like it? Yes, I do. on the outside. So you don't know an answer to my question? No, no, I don't know the person, I don't know who. My husband did not say that. And to conclude this round of questions. So a car was purchased. It was 4 years old. It was imported for 211,000 lei, which was certified by the customs service, and we provided you the information, and I understand that you don't have any objection to that. So please allow me to ask the question. When asked why the declared purchase price is twice lower, you said that probably, I just want to understand this specifically. Why is it 2 times lower? I mean, it had some defects? That car had some defects? Yes, she said. If it had these defects, please inform us what's its shape, was it repaired, give us some more information so that we can understand why there is such a big discrepancy. I was waiting for your second question. I'm learning to answer briefly. I'll spend some more time here. You'll like me really the way I answer. Please continue. The car was corroded on the bottom. I was told that this is how cars come from abroad, like with little corrosion. Then my husband did not tell me from the beginning, and then I saw that money is going out from the family, and then I understood money was being spent to repair it, and he was, you know, very careful with the cars. He repaired it. All this corrosion was gone. Pardon me. We improved it on the outside, cleaned the inside, and then sold it for the same amount because it did not have the deficiencies it had initially. But he invested into the car to bring it into a good, because we know that corrosion destroys everything. That's how he explained me the difference of why he purchased it for this amount and sold it for the same. Because even though we used it for 2 years, or I don't remember exactly how long we used it, but we invested in it. And it was much better when we sold it than at the moment when we bought it. And honestly, buyer came, he fought for 6 months, and then he came back to us and purchased it from us because he saw that the car was brought to a good shape. I can't say anything else. Thank you. Accepted answer. Another perspective of the same question. So we'll go through the time. In 2017, when you sold this car, in your 5-year declaration, you mentioned that the sale price of a car in 2017 was 100,000 lei. Do you confirm that? If it's in the declaration, I do confirm. It certainly is in the declaration. And if you have any doubts, please look into the documents that were provided to you, because all this information was provided to you. Well, I don't take things that seriously as you are. I understood it. Can I continue? Yes. So I said in your 5-year declaration, you said it was 100,000 lei. We asked the contract for the sale of this car in 2017, and the value we found there was 50,000 lei. Do you confirm that in the sale contract, can I confirm that it was my husband's signature in that contract? I confirm. So do you confirm? I only now saw it in the contract. And in this context, why is there a difference, double, it's twice the amount? In the declaration you have 100,000, in the contract is 50,000. Because I know that's what my husband sold it for. I did not see the contract. My husband told me 100,000, that's what I wrote. I didn't have any intention to lie. So you did not see the contract? In what contract? You submitted it to the commission. Well, that's when I saw it. Well, it's good that the pre-vetting commission exists. I am glad you have such an approach towards our activity, but still, how do you explain the difference? Because I want to understand that it's 50,000 in the contract, because I was not part in the sale, purchase, selling. Now I saw in the contract, it's my husband's signature, and he can make my signature as well. If I may, and if my colleague doesn't mind, it's very rare when the declared amount is twice as big as the amount in the contract. That's why we want to clarify. I understand that when you filled out the declaration that you filed to the Commission, you relied only on what your husband told you, who told you that he bought it and sold it for 100,000. Is that right? Yes, you understood it correctly. I am responsible for my actions only. I was told 100,000. I saw this money in our home, and that's what I declared. What was in the contract? Unfortunately, I did not check that. But do you have any information when buying or selling this car? Was any tax paid by the husband or by the buyer? No, I don't know, but this car was registered on my name. Probably I was the one who was supposed to declare it, but I think I was already in Italy by that time because we were in big need for money. I don't know. I don't know if I was in the country or not because I was not part of selling the car. According to the legal provisions, a tax is paid only in case of a capital gain. And for instance, say you sold it for 50,000 or 100,000, you did not have to pay taxes given that the purchase price was 100,000. Do I understand it correctly? Honestly, I did not think about it, but I am glad that I declared what was real. And once more, you know, I get convinced by the fact that the truth will always save you. Thank you for your answer. And almost the last question about selling that car. Well, last question about this car. So the purchase price, the declared purchase price was 100,000 lei, and you reiterated. So this car in 2015 was purchased for 100,000 lei. It was also you who declared that it was in an unsatisfactory shape that allowed buying it at a much lower price than the import price of that car. It's almost twice lower. And the reason was like various deficiencies like corrosion, well, technical defects, let's say. Pardon me, I think he even changed the gearbox, I think she meant. It was very expensive and we even had a quarrel about that. Well, in the context of the aforementioned, I understand that big investment was made into this car. I mean, meaning that repair works, gearbox changed. So 100,000 paid for it plus repair expenses, sold 2 years after for 50,000, confirmed by the contract, sale contract. Well, may I continue? So what is the economic rationale then? Buy a car for 100,000, invest money, and in the end, sell it for 50,000. I had a very bad health issue. In this case, you are not looking for rationale. You look for money, so that you can just go and live somewhere, not under a bridge. Your answer is accepted. Well, very similar questions, but we'll go, I hope, quickly through the last situation that we identified as an issue, and that is about Dacia Duster. In 2017, your family purchased a Dacia Duster car, manufacture year 2010. In your 5-year declaration submitted to the Commission, you declared that the car was purchased for 50,000 lei. That's estimated to 2,500 euros. You also provided a copy of the sale purchase contract, which reflects that 50,000 lei price. At the same time, according to information from the Customs Service that identified value of similar cars, in 2017, a Dacia Duster manufactured in 2010 cost around 80,000 lei plus customs duties around 20,000 lei, which means around 100,000 altogether. The price you paid for it is twice lower than similar cars evaluated by a public authority. So, in this context, would you confirm that you purchased this car in 2017? That was purchased by my husband, as far as I remember. It was my husband. He... Well, we talk about your family. From what I remember, well, I certainly know that because I asked, the car was hit in an accident. This car had that's why he got it cheap. My husband checked it. He saw the part of the car, side of the car was hit. That's why he could buy it at a lower price. We know very well that 80% of the cars that get into our country, they had similar defects, and then they are repaired. At least that's what he told me. I don't remember right or left side, but on one side it was hit. It looked new, but it had a small traffic accident abroad, not here, because it was brought from somewhere. Not. Given what you said, it was hit and it was imported, being hit after this accident. Well, when we purchased it, you couldn't see it, so we didn't have it. But my husband checked, because things like that can be checked very easily. So it was repaired by the owner from whom we purchased. Yes, when we bought it, it was to finish this quick. I'm sure if you answer briefer, we'll move on. So, did you purchase this car in 2017? Yes. At the time of purchase, since it was manufactured in 2010, it was around 7 years old, probably, so I'm not good with math at all. In the 5-year declaration submitted to the Commission, you mentioned that you purchased it for 50,000 lei. And this was proved by the purchase contract, purchase agreement. You don't disagree. Well, what could I say now? I told you mostly my husband did that. I mean, not majority, but like 99% of this was done by my husband. So you partially answered this question when we started this round of questions, but our thinking or our suspicion or our unclarity or what we don't understand is that you purchased a car for 50,000 lei where the customs service assesses such a good for 100,000 lei. Could you please explain the difference? And again, I regret that for asking you the same question again, because partially you explained it, but you have a chance to elaborate now on it, to add something. Why there is such a difference? I believe that my husband is an expert in this field. He was and he is, and I always tend to listen to him in regards to cars, because I don't understand things in this, and I don't pretend to. That's why I trusted him entirely to handle all operations and transactions as he deemed appropriate. Of course, I was asking him because I needed for the declaration, and what he told me, that's what I wrote. Personally, I did not have this question or issue under control. As I understand, then and now, the control is good, but not 100% control, because there is also trust in a family. And if I were to keep everything under control, you know, in our Moldovan families, it doesn't work for the wife to tell what she thinks of cars. Well, I always said that it's good to be a new car, have a receipt, you know, that I promote truth, kindness, and tolerance. I don't want any shadow to be cast on my work, but unfortunately, things don't always work as we desire, or as I desired in this case. I believed him. And, well, on the amount what he told me, that was the amount leaving the household, that was the amount coming into the household. I did not have any under control. It's only now that I saw the contracts, because since he worked in Kalarash, he was drafting all these contracts. Did I have to go and check on him? I don't know. You know, maybe there is some discrepancy, as you say, with coming into the customs. I did not look into this at all. When I buy a car for myself, personally, a personal car, I will respond to this question, but now I have nothing else to add. Last question, and I will have no more questions afterwards. Now you mentioned that this difference between the purchase price and the price assessed by a public authority is due to the fact that it was hit. But previously, we asked you, the Commission asked you about this during the Q&A round, and that's why I'd like to ask you, was this information communicated to you, well, when were you informed about this? Recently? Because previously you did not mention this. I think I wrote about that, but if I were to come up with some details, because anyway, I will do that in the end, and what is not in your materials. Now I work Monday to Sunday on two jobs as part of a refugee crisis. I don't know who. I don't want to suspect anyone or to express my lack of gratitude, but you always sent me questions on a Thursday evening, 7, 8 o'clock in the evening, and gave me deadline until midday on Sunday. I'm sorry, when am I supposed to work with authorities? When Friday, I have all day scheduled for working. Territory refugees are waiting for me because I told them I'd come. And maybe I missed something. It was really difficult to stick with your timeline, with your deadline, sorry. And I discussed this with my husband because I was highlighting with, like saying, you answer that, explain me what is happening. But 3 days out of which are weekend days, honestly, it was extremely difficult to do that. You know how we can try to address public authorities. My husband is retired now. But, okay, he still has some good relationship, and please give me that, but this can also be treated as traffic of influence. We're all equal. If we file an application, we have to wait for a certain time. I did not want to violate this rule, but I had to. I said, please, this contract, that contract. It's also our mistakes that we didn't keep copies of that, but sorry, my husband has been retired for 6-7 years now, because we also had the question, why did we donate this to our son? Why? No reason behind that. We were not public people. We did not claim anything. I did not file any request to get employed or anything. It's just at a certain age you start settling things, because my husband is a bit older than me, and he wanted to ensure that there is clarity, especially when it comes to land plots which did not belong to me in any way. And in this case, I accept that maybe I made mistakes. I actually wrote in my last answers to questions, I am extremely tired. I put things to scan into the printer, I forgot it there because it was 10 to midnight. Like, sorry, but I have to go to bed at 2 past midnight. But if you need any more clarification, I'm ready. I was just thinking that I wrote about that Asta was also hit. This car is still ours. We could go there. Anyone can assess it. I am not afraid. I have nothing to hide. We sold a more expensive one, bought a cheaper one just to have something to travel you with. I did not intend to hide anything. What is declared in the customs, I don't know how this mechanism works. I don't know how people sell their cars, but with the Asta, I was at the car market, and I took a glance at the prices to see what we can afford, what money is left, and how do I move on. That's everything I can add.
Thank you very much, Madam Chiriac, for all the answers you provided. Esteemed Chair of the Commission, I have no further questions.
Are there any other questions from other members of the Commission? If that is not the case, then I would like to give you an opportunity to make a brief closing statement, and then we will wrap up our session. So if you would like to take a time for a brief closing statement, then please go ahead.
I think this is rather going to be for the media. But I would like to say something about you too at the end. I can't keep silent. I am a person that cultivates. I do not believe in Darwin's theory of evolution. I think that everything is seen and everything is known. It is very easy for me to leave. When I know that every thought and every act is seen and known, in Moldova, I believe everybody is aware about my civil society activity. I am the president of the association Falun Dafa and Falun Gong that is based on three principles: the principles of truth, that is being honest, benevolence, as in kindness. I guess I don't need to look further into that, and tolerance, which means having command of oneself. And thus, for 20 years, having promoted my activity in Moldova, I've always tried to be honest and fair in my actions and the transactions I was part of it, the activities I engaged in, and even in my thoughts. Unfortunately, this has also put up a lot of barriers in my way, because I might get a little bit philosophical, but where there is kindness, where there is good, there is also evil. I preferred not to fight evil. I preferred to pay attention to my own weaknesses, to what I needed to straighten up and to write about myself. As much as I could for a human being, I tried to get right the things that I thought I had to. People can have a lot of bad habits. What I wanted to say is that I am here without any fear whatsoever. I did not hide anything, and although I said I would never return to the judicial system, I realized that that's how I felt at that time. After I have gone through some obstacles in my life that were quite harsher to overcome, I realized that you must make yourself useful as much as you can. I don't know what your decision will ultimately be. I don't know what the decision of the parliament will ultimately be. I'm not here for a career or to be popular. I'm only here to give the younger generation of judges hope. Hope that by making a step back, you can end up winning more out of that. And if we really will be successful in setting up a Council of Magistracy, one that is at least able to listen, I have never been listened to. All the times, always, whenever I go to the Superior Council of Magistracy, I felt like I was going to the scaffold. But this cannot encourage a judge to feel confident that they are listened to, supported, and encouraged to be honest, to be kind. And one's intimate beliefs need to be based, to stem from one's morality, not from what the colleagues from the Supreme Court of Justice say, not from what they will say at the council. As in, they will not listen to me. They will tell me to step outside of the office and stand behind the door. I think that in my lifetime, after I left the judicial system, that part is a living example. Even if you're not going to be a judge, you will remain a human being. The laws were given to people by the divinities, but it's only that we forget about it. And although we have extraordinarily perfect laws, we don't have better people. Regardless, we don't have justice seekers who are happy with it, because in my opinion, the judicial system of the Republic of Moldova has lost its footing in reality, in humanity, in empathy, and has lost its connection with the justice seekers. It has all turned into a machine, a system, but it only works till a certain moment in time. And I think now we've reached the climax of it. And having this belief that everything that gets to that point, to the point of the highest point, the summit of evil, were turned into the reverse of it, I decided thus to be part of this change towards the better. One's own belief cannot come only from judicial practice. It comes from one's life experience. And therefore, on my platform too, I said that a judge needs to be helped to remain humane. A judge is not a machine, a mechanism, just reading out the law and enforcing it. And if I said that I would talk about you, I know that at the end your beliefs and my beliefs are absolutely opposite to one another. And I will not look into the details of that now, because judging by the questions that you ask, I knew it was you based on the questions that you asked, although they were never signed off with your name, but that's a different matter. And there's another thing that I would like to go into. Maybe you are already bored of my speech, but still the fact that for 20 years I've been talking about the crimes of the Chinese Communist Party that has made me more resistant. It has made me feel more courageous and wiser. And I have the wisdom to understand that everything passes. And a choice can cost you life. One single thought will put you either into the realm of the good or the realm of the evil. This is specific of the historic times that we're living in. Thank you from the bottom of my heart. If I've ever exaggerated, if I ever wasn't able to deal with my emotions and feelings, that's the hardest to keep in rein, I would like to apologize, but I'm very happy that I made it this far to be here in front of you. And although I made certain mistakes, because I certainly, it's unavoidable to commit mistakes, I will try to make things right. And although, even if I will get there what I want to be, I will continue to be the same, honest, kind, and tolerant. It's only that these principles are very profound. Thank you.
Thank you very much. With this closing statement, we've come to the end of the hearing for today. I thank you for your comments, your answers to all the questions that we had, and as you know, the Commission will now withdraw for deliberations, and as much as possible we will strive at delivering a decision within a month after the date of the hearing. I thank you, and hereby I declare this hearing closed.